The hustle and bustle has officially started. The parking lots are full, the shopping malls are filling up, and for personal injury lawyers like David Hollingsworth, this can actually be a lucrative time of year, but that's not so good for the people who may be slipping, falling, or getting bumped into. What would you like people to know when they're out there in the busyness if, in fact, they injure themselves? Don't be embarrassed, hop up and go home.
That's right, Leanne. I mean, last-minute shoppers have to beware. It is a very busy time, and certainly in the big stores, there's a lot of hustle, there's a lot of bustle. A lot of the typical perils that can happen in a store are even greater when it's busy. Boxes falling down, display cases getting in the way, slippery ground. What happens often is people will fall, and if they aren't so severely hurt that they're stuck there, they get embarrassed, they get up, and they run out of the store. If that is you and if that happens, it's very important to get back in touch with the store if you've been injured. Number one, you want to let them know if there's a danger. But number two, if you've been hurt and you're considering making a claim, you want them to know. You want them to record it, get the name of the person you speak to, and ask them to maintain any video coverage that they may have of the incident.
That's such a valid point because we're actually being videotaped pretty well always, pretty well everywhere. So the likelihood is there will be a video camera that will have caught the incident.
Exactly. Exactly. Ideally, you'd stay there and you'd fill out an incident report on the spot, but that doesn't always happen. But even in-store is not the only type of peril. I mean, obviously, in the parking lots, there are people trying to find parking spaces, people carrying bags, not paying attention. If you're hit as a pedestrian in the parking lot, same thing. Make sure that you stay. You get all of the information of the driver that struck you, or if you struck somebody, be sure to share your information. We just have to be that much more diligent this time of year because there are so many more people around.
One of our questions today actually relates to that, but one of our quirky cases relates to this as well. You have an interesting case to discuss that did take place in a parking garage, and a pedestrian was struck by the
security arm. So what happened was, we've probably all done this. Somebody was entering into an underground parking garage in a vehicle. The security arm was triggered. It lifted, and then a pedestrian snuck behind the vehicle to get in as well, but not quickly enough. The security arm came down, struck the pedestrian in the head.
Head injury.
There was a head injury, and what makes it quirky is that the courts considered this to be a motor vehicle accident, even though the pedestrian was a pedestrian, not in a car, and was struck by something other than a vehicle. They found that because the vehicle is what triggered the security arm to go up and down, that it was a motor vehicle accident, and as a result, the pedestrian got all of the benefits available to somebody who's been in a car accident.
And that was actually a surprise. It was an interesting case for a lot of people.
Well, they thought outside the box.
We have another one relating to sort of a box or an elevator, just quickly, because we are going to get to your questions, but this is really interesting for those of you who are phobic about elevators. This case may make it worse, but David, tell us what happened.
Yeah, a 72-year-old woman in Toronto was in an elevator, and the elevator was going down and it got stuck. A bit of a worse nightmare. She was knocking on the elevator. Nobody came to her assistance. She actually had the wherewithal to pry it open a little bit. She looked down, she could see the floor below her and said, okay, I can probably make it. And as she went to exit the elevator through this crack, the elevator jumped again, sent her out. She fell to the floor, actually hit a pillar, fractured her shoulder. And when it went to court, the court said that it was not the elevator's fault or the elevator owner's fault. It was, in fact, her fault in part because she was safe when she was inside the elevator. It's when she tried to get out on her own accord that she was injured. So that's also an unfortunate and quirky case. There are elevators in shopping malls as well, so beware of that.
So many people who are watching this are thinking, oh, that's the worst nightmare, because everyone would have tried to do that. Wouldn't you have tried to get out of the elevator? We want to get to some of your questions, and we'll get to a couple before we take a break. This one is, this really relates to the Ottawa condo market. I recently made a down payment on a condo that will be built in 2016. After I paid, I fell in love with a different condo that's ready right away. Can I get my money back since it's not for another year? Will I need to hire a lawyer?
Okay, well, first things first, look at the agreement of purchase and sale that you have. Odds are you can't get your money back once you've paid a deposit. And usually on new condos, they're large deposits. You may have also paid for some upgrades or ordered some upgrades. You're probably going to lose your deposit if you try to walk away. And if the condo seller, if it's a soft market, if they sell the condo for even less than the deposit and the upgrades, they could even come after you for the difference. There are outs sometimes if they delay the construction of the condo and they don't give you the proper warning in that. There may be ways out, but don't count on it.
Interesting. So really look at your agreement before you even proceed with a lawyer. Next question. I was in a small car accident just yesterday. We both agreed that we probably didn't need to call police and exchanged information. Is that okay? This has happened to people who are watching.
Sure, absolutely. I mean, is it okay? It's legally okay, but the problem that you face is that if you go to your own insurance company and you say you need something fixed, they're going to say, well, who was at fault for the accident? Because if you can't establish that it was somebody else at fault, you're going to possibly have to pay your deductible, which is usually around $500, and your insurance rates may go up if you can't show that it's somebody else's fault. So take pictures, exchange information, but unless you're sure that you're going to be able to show it's the other person's fault, then I would definitely call the police.
Okay, thank you so much, David. We're going to be back with more of your questions and our lawyers' answers. Lawyer David Hollingsworth is here with free legal advice. Everyone loves free legal advice, and we have a really great variety of questions today. Moving along with the questions, is it true that if I have a party at my house, I am responsible for anyone leaving who may have been drinking and then driving?
The answer is potentially. It all depends on the fact.
Definitely. I thought the
within the confines of your home, but once they leave, there is that big case that happened here in Ottawa a few years ago regarding social host liability, where the courts left the door open to social hosts being liable. So, for example, if it's a BYOB type of party, less likely to be responsibility on the host. If the host should recognize that somebody is intoxicated, they have more of a positive duty to ensure that that the person doesn't leave and get behind the wheel of a vehicle. Practically speaking, anyone leaves your house and they're intoxicated, make sure they get into a vehicle where they're going to get home safely and they're not
always
driving.
Make the right choice.
Yes, exactly.
Whatever the liability issue is. Here we go.
That's right.
I just heard that there's a new law that I can't fight my insurance company if they deny my claim after a car accident. Is this true?
Yeah, so I've probably fielded 20 calls asking this question in the last week or so. There's a bill that's recently been passed, Bill 15, and among other things, it says that if you are receiving accident benefits from a car accident and your insurance company denies you a benefit, they say, okay, we're not paying for physio or whatever that benefit may be, it used to be that you could go through the Financial Services Commission to fight it, or you could go to the courts. Now this bill that is passing says that you can't go to the courts anymore. You have to go through what the Financial Services Commission, and it's run through the Licensing Appeals Tribunal now. So you can still fight it, it's just you can't go to the courts to do it. You have to go through this Licensing Appeal Tribunal.
So there is a way to fight it, you just have to go in a different direction in order to fight it.
That's right.
This actually could relate to the 20 calls you've fielded. Are you able to bill, or are those people able to be billed by you? If I call a lawyer and ask a few questions, can he or she send me a bill?
Well, I guess the short answer is anytime a lawyer spends time providing you with legal advice, in theory they could send you a bill. Lawyers have rules. They are supposed to meet with you. They're supposed to get a retainer agreement signed. They're supposed to get a copy of your identification. So, normally that would happen before they're going to send you a bill. But if you want a free consultation, make sure that you confirm at the outset that it's a free consultation.
Okay, great. I can assure you this is a free consultation. David will not be sending you a bill for our time together today. You're not, are you? It is true that if I apologize to the other driver, I'm sorry, is it true if I apologize to the other driver, it can be used against me when settling a car accident lawsuit? I have heard this so often where people don't actually say the right thing or what you'd expect someone humanely or with humanity and kindness to say when someone falls either on their property or is injured on their property or in a car accident.
Yeah,
what's the story?
That's a tricky one, because I have a lot of people who call me and they were not going to take legal action, but they're so upset that the person that maybe it was the cause of their injury, didn't apologize or didn't call them to see how they were doing. There is a law that was passed a few years ago called the Apology Act, and that essentially means that if you apologize to somebody, it can't later be used against you in court. There are exceptions. One of the exceptions is if what you're apologizing for falls within the provincial offenses mandate. So if it is a Highway Traffic Act violation and you rear-end somebody and you apologize to them for that, the law says that they can use that one against you. Or if you apologize during the course of legal proceedings, that can be used as evidence. But in another scenario where I guess if somebody slips on your property and hurts themselves, if you apologize.
Someone trips over your dog because the dog darted in front.
That kind of thing.
Those sorts of
Yeah,
issues.
that type of thing. Then if somebody apologizes and does the right thing by apologizing, that later is not supposed to be able to be used against them in court.
That was
according
really
to the Apology
interesting.
Act. Yeah?
Thank you for that question.
So apologize.
This is really timely. Do I need a lawyer to sign a letter if I want to take my daughter to Florida for a week and her mother isn't coming with us?
Yeah, it's not a legal requirement in Canada. However, it's strongly recommended. It just makes life easier for the immigration officers and for the border officers. Sometimes they'll ask for it, sometimes they won't. You don't know if the country that you're going to is going to require it. It's easy to get. There's a standard form. I think it's on travel.gc.ca, but in any event, it's easy to find a sample form online, and you might as well get it done.
I'm trying to sneak this one in really, really quickly. I'm just waiting for the big snowball where my neighbor always pells all of the snow from his laneway onto my front lawn. Do I have any recourse?
Yes, you do. Firstly, of course, try to speak to them about it. Sometimes emails lost in translation. Talk to them first, confirm it with an email. If they aren't going to budge, then you can contact a lawyer. The lawyer can bring an application to the court to get an injunction, preventing them from doing it any further. And you can seek costs if they cause leaking in your basement or wreck your grass or whatever. You can seek costs against them for your losses.
We covered a lot of ground, wide and varied, plus the quirky cases. Thanks so much, David, for joining us. We have a link on our website to David Hollingsworth's website, which is ottawainjury.ca.
Thanks.